I hope you all got the opportunity just to read the quote that was left on the screen, because it does set a tone that perhaps everyone in the audience is more than familiar with. And whilst it was it's absolutely a privilege to come and speak at these functions, a little bit later I'll tell you my first experience at raising this issue when they weren't actually expecting it at a conference. But before I do, I want to tell everyone, if you're expecting a detailed analysis of any law, it's not going to happen, because we have a mixture in the crowd and we don't have the time. I can see some sighs of relief. There will be some references to law, but the emphasis is going to be primarily on the UK and the Cayman Islands, because that's where I've been practicing for the last 11 years. And whilst I'm sure there are provisions in the Australian law that are equal, I've seen some of them, I don't feel confident enough to come and speak to especially people of your calibre about the detail of it, because undoubtedly you'll pick me up on my errors. But today there'll be something pitched for academics, government official, compliance managers, and of course lawyers. Much of what I aim to do today is hopefully have you go out, leave the room and think about it, and think how you can progress it in the capacity or the context of each of your positions. As you'll see, there's a lot of industry criticism when it comes to compliance issues in this context, and the criticism comes from the fact that at times we can be too academic with our approach, and if we really want to sell the idea to industry, including banking and whatnot, you've got to make it real. That's what they say, but again, as you'll see, they don't like it too real. Now, before we go any further, I wouldn't mind conducting a brief straw poll. How many in the room are criminal prosecutors? Come on, please have one. No one's an actual prosecutor? I'm disappointed, I really am, because I'm sure they got an invitation. But don't worry, I came prepared with my slide. Is someone not admitting it? Look, can I go to the next step? Who has been a prosecutor? Great, you'll do. You'll do. I'll call on you later. How about regulators? Do we have any regulators? Yeah, oh great. Well, that's a natural progression, I guess. And anyone from banking institutions? Yeah, surprise. Yeah, compliance officers? There you go, all the people it's directed at. All right, well in 2008, I just arrived in the Cayman Islands, not too long, a few months, and I was on a sabbatical. Well, I still am actually on sabbatical from the United Kingdom as a prosecutor with the Crown Prosecution Service. It runs out in February. Like it or not, I won't be going back. But what had happened was, when I'd come over, the director, she was Solicitor General at the time, was invited to give a talk at one of the major magic circles or top tier firms' compliance seminars. And because Cayman Islands had just introduced the Proceeds of Crimes law, which was basically a replication of the Proceeds of Crimes Act in the United Kingdom. And she said, would you mind taking my place and addressing this seminar? And I said, yeah, look, that'd be great. Now, I had mistakenly believed that what they wanted me to do was to highlight the criminal risk for officers, directors and managers. It was in a lovely ritzy hotel on Grand Cayman. Remember that? Might be useful for you in a little while. And in fact, all they wanted me to do was to tell them a little bit about the new Proceeds of Crimes law, as it was there, and how we would deal with the baddies who were caught with funds in the Cayman Islands. Little did they know that the criminals I was talking about, or about to talk about, could be seen if they looked in the mirror. I come to you today having only just returned to Australia in April, and as I said, I'm still familiarising myself with the relevant local laws. So what I am hoping is, over the ensuing months and years whilst I'm here, I can assist in developing the evolution for Australia, because even though we're probably lower risk than a lot of other nations, I think we are lagging a little bit behind with our approach in relation to our views in relation to money laundering and whatnot. When you speak at a macro level and you start talking to compliance officers and whatnot, one of the things you notice is they never address criminal risk in their risk compliance matrices, in their manuals. My experience to date is actually that when you go to these conferences, and I'm sure a lot of you have, they tend to focus on either prosecution. For example, if you go to the Economic Crime Symposium in Cambridge, the emphasis tends to be on the prosecution aspect, because you have prosecutors from all around the world there and attorneys general, etc. Or they focus on compliance if they're run by the private sector, and they tend not to touch on crime at all. By the way, if any of you have a budget to go to a seminar, and it's one a year, really think serious about the Economic Crime Symposium. This could be the last one, and is an experience once you've had it. I'm sure those in the room who've been to it will tell you it's like nothing else you've experienced when it comes to conferences. You start at 7 in the morning and finish about 7 p.m, and it's full on for 6 days. So, and the information and networking it gets incredible. Anyway, enough for the advertorial. But my experience to date is that conferences need to actually straddle both. Now, I suspect it is merely a symptom of the embryonic stage we're at in this type of risk, and everyone is still trying to find their feet. It is imperative that the time is used constructively to make sure that institutions acknowledge the risk and have everything in place to cope with the requirements. And one of their biggest problems is they lack a culture of compliance. For example, if I can just throw the question I usually throw out, why should you be compliant? Anyone want to offer an answer? Shout one out. It's very rarely I get the obvious answer, because it's the right thing to do. No one ever starts with that. If you basically ran your business in accordance with your morals, and let's not deal with the fringes, let's deal with most people, you probably find that you'd be running a compliant business. The formula is not that difficult. It's the corporate veil that causes a lot of the problems. Now, all banks undoubtedly have compliance manuals, but how many banks have a compliance manual or a risk matrix that acknowledges that senior officials risk terms of imprisonment of 14 years or more, life imprisonment if it's conspiracy in some jurisdictions, because it's still a common law offence? How many in the room today truly, for example, considered the difference between the roles of regulators and prosecutors? That's probably a good starting point. We all know what they are, but have we actually ever considered the roles of each? Now, regulators tend to be more concerned with making sure that the laws are complied with. Whilst in most instances they have powers of persuasion, their role is more akin to assisting with compliance, and that's properly so. In much the same way as a fire warden may come to your premises to make sure that your fire alarm's working, that your extinguisher's filled, that your stairways aren't blocked, that everything else is up to standard. If it's not, they'll write out some sort of violation. You may even get a small fine. But once the building catches fire, it is far too late to speak to the fire warden, and it's time for the firefighters with lights and sirens blazing to take over. The catastrophic event has happened. Now, prosecutors are not fire wardens. They are firefighters. And they have not come to your office to hold your hand, as a regulator might. When I first suggested using the same direct approach, for example, because I was addressing a compliance seminar as a prosecutor, I was met with responses from the audience, and I mean it was shouted out. I've never seen anything like it, especially in a place where you had business people, compliance officers. You're a maverick, and one guy said you enjoy your job too much, right? I also said to him, look, I predict in 10 years criminal prosecutions for your type of regulatory breaches will be high on the agenda. It turned out I was wrong. It only took months because I'd addressed, I think, 2 or 3 months before the Madoff affair, right? And it was funny because I was just telling Russell, as soon as I went back to the office, I thought I was going to be lynched. Thankfully, I had a police officer with me who was also on the panel. And I went back to the director. I said, look, I have absolutely no doubt you're going to get a complaint. I had no idea what they wanted me to speak about. And I wasn't saying anything sensational. I was just matter of fact, as prosecutors tend to be. Didn't sugarcoat anything. Showed pictures of the inside of a cell, things like that. And she said, oh yeah, it might have been a bit over the top. You wouldn't believe it, after the Madoff affair, she had to put, well, it wasn't a written direction, but she said we have to filter and start being more discerning at which of these you can speak at, because we were getting invitations left, right and centre to speak at these things. So finally it took such an event to put it on their agenda. But one of the things I indicated to people, and perhaps many in the room mightn't have gone through the process, but it just sort of sits there, we know it's there. How does a prosecutor get involved in a matter? And just consider the process of a matter coming to the attention of a prosecutor. A complainant, usually a victim, has complained to police. A team of highly trained police, and when you're talking about financial crime, anti-money laundering, they are very highly trained, have undertaken an investigation and delivered a brief of evidence for sign-off by another senior officer who also has the role of gatekeeper. So you'll usually have an inspector or a sergeant who's been in the job for maybe 25, 30 years, going through the brief and saying, yes, I think you've got enough matter to, enough evidence to refer it to the Director of Public Prosecutions. And that's when it ends up with, as it was with me at the time. It would almost have to be exceptional that I'd form an opposite view. Just think of the process it's gone through before it's actually come to me. I never went out looking for the work. Believe me, I never went out looking for work. It had to come to the desk. So, how does a prosecutor decide whether or not to prosecute? And whilst it's acknowledged in writing in the United Kingdom, I'm sure it's done here, it's done through what's called the full code test. There's actually 3 stages, but I won't go through the third one. It's not really of concern in this type of crime. You have the evidence test. Well, as that suggests, you just go through it all and you see if there's all the elements of the offence are covered and whether you've got a realistic prospect of conviction. Then you also have the public interest test. Is it actually in the public interest to prosecute these matters? Ideally, as far as corporations, banks, etc. would be concerned, it would be great for them never to meet the evidence test because their compliance regimes are that good. It's extremely difficult to do so because you can't control everyone all the time. So where their emphasis should be actually is in the public interest test, because when you're deciding whether to prosecute or not, you actually start looking at what efforts have they actually made to be compliant. And one of the interesting things I was told about by a financial investigator, he says, you read about it, you hear about it, people joke about it. He said, I actually saw it. He said, I walked into a bank and the compliance manual was used as a doorstop to keep the door open. And he said you wouldn't. He said if he had his camera, he would have taken a photo because he didn't think that people would believe him, because they're always thick, they're very effective, and they're great for cross-examination. They're fantastic. Your best friend and your worst enemy are 2 things: a compliance manual, because if you're a compliant, it'll be your best friend. If you don't know what's in it, it's your worst enemy because you cross-examine on it. And then my next favourite tool, the thing I love, and we've all grown love to hate, is email. People forget that unlike a telephone conversation, an email is there forever. So those are two things to watch out for, or if you're in the prosecuting agencies, to look for. But prosecutors are an all or nothing type of creature. That is, if for some reason they choose not to prosecute, nothing more will be said. If, however, they do, the only types of negotiation they get involved in is plea bargaining. That is, what charges to have the defendant plead guilty to, how much of a fine, the terms of imprisonment in some jurisdictions, and where relevant, restitution and confiscation of proceeds of crime. Now, the reason I emphasise that, I think you'll find with a lot of corporations, and again, when I say corporations, I'm using the term interchangeably with banks, because they're featuring, they've always featured highly, but even more highly of recent times. And they always think, let's just talk to the regulator, make all sorts of promises, and we'll do this, and we'll give undertakings, and we may even pay a fine, which, by the way, I've worked in these private institutions. It's built into the margin, people, that they actually budget for fines. You'll never find it. It'll be, usually you might find it in a charity fund, money for charity. So if they get fined, guess who cops the penalty? Is usually a charity, right? So it does happen. But the reason with prosecutors that won't work, and the reason is it comes down to, and I'm using industry term, I hope it's still used, is key performance indicators. The key performance indicator for a regulator, and I know I'm simplifying this, and I don't mean to offend anyone by simplifying it, when they're measuring whether a regulator's doing its job, they tend to focus on whether the industries are compliant. If they are compliant, the regulators are given the appropriate credit for their involvement. In fact, if a lot of people are non-compliant, besides institutions themselves, of course, they start looking at the regulators as well. The key performance indicator for prosecutors are offenders brought to justice. It's no good for a prosecutor to agree not to prosecute someone, because it won't show up on their key performance indicator. And that brings me back to the initial point I made earlier about the negotiations work out, look, will you plead guilty to the 5-year offence or the 14-year offence? And that's what it boils down to, because if they say, look, we just promise to be compliant in the future, so great, because we'll include that in your bond, right, if you're lucky enough not to go to jail. And what people don't realise is the death penalty does exist in Australia. The death penalty for corporations. If they want to be entities, remember, we can liquidate them, we can wind them up. One interesting point for the academics amongst us, I've always wanted to research, and perhaps may I suggest that you set it as an essay for some smart law students, so it saves me a lot of work, is can you have a conspiracy between a corporation and a director in a one-man corporation? Because if they're a separate entity, why not? In principle, it seems to work, but there's probably a case or an answer to that. Now, what I'm going to do is I'm going to give you an example of a typical case that prosecutors may come across, and I've deliberately pitched it at a low level because what we were doing in the Cayman Islands was encouraging prosecutions for anti-money laundering under the Proceeds of Crimes law. And even that evolution was interesting to watch, because having come from the UK, I was the only one who was using the legislation, not because I was any better than anyone else, it's just I was more familiar with it. And it got to the stage that every time a particular charge came along, they'd actually say, oh yeah, Masters, laid that one on, because I was getting a hard time from the bench in relation to that comment we first read from Justice Ungood. But the bench started coming around. What was good is after about 4 or 5 months, the prosecutor was saying, no, actually, he didn't authorise that charge. It was another prosecutor. And now the question doesn't get asked anymore. Of course, it can't be attributed to me because I'm not there anymore. But I'm told that they're pushing the agenda along. And what that tells you is that it is now on prosecutors' radar. It wasn't that they were disinterested. It does require a certain level of interest and skill in financial crime. Let's face it, any lawyer that's half competent in financial matters won't get into crime, right? They'll go to somewhere where the money is, probably compliance or mergers and acquisitions, but that is changing. And if I had more time, I'd actually go through some of the incentive schemes. I might touch on them today as to why it's going to be a real risk for business. But anyway, I've used the facts of a real case that happened in the Cayman Islands, but I've changed the name. Don't know why, probably don't have to, but I'm just inherently scared. I reiterate, however, that it can happen anywhere in the world. And I've deliberately, when I do make slight references to the law, have referred to Cayman Islands, I think I indicated earlier, just to show that it's not just the big Western world countries that deal with these. These offshore jurisdictions actually are quite proactive. It's just that they're small. They have limited resources. And by the way, these predicate offences aren't actually committed in these offshore jurisdictions. They're committed everywhere else in the world. So somehow these people are meant to investigate other people's crimes. So we've got to be realistic. Another way I want you to start thinking is offshore is a relative thing. I used to have 2 offshore accounts. One was in Australia and one was in the UK. And that was because I lived in the Cayman Islands. Offshore is a relative thing. So keep that in mind. As I've said, I've deliberately started with a low-level offence in the hope that it drives home the gravity of the risk to financial institutions in particular. What is interesting is everyone can appreciate in this scenario the predicate offence and why the first person should have been prosecuted. But I want you to start thinking differently now. Start thinking about those who facilitated the offence. If you've got nowhere to hide your money, if you can't put it in a bank account or somewhere, the crime can't happen. So these other people are involved in the crime. And it's interesting, they either know, they don't know, or they cover their eyes. And you'll be amazed. I always thought it was covering the eyes. It was covering the eyes because they know. And that was the problem which HSBC, which we'll touch upon again. I would love to prosecute that case. I would absolutely... You know, I've had murders that were more difficult to prosecute than that case. I've read about 3 of the emails and said, there you go, you don't have to prosecute them with 1,000 offences because of the way the law is structured. You only have to be lucky once. In fact, one police officer addressing a seminar said, when the law first came out in the UK, they have given us an exocet missile, we just need to take it out of the box. And I tell you what, he was quite right. But anyone who has read the recent US Senate report involving the HSBC would appreciate from where I am coming. However, I will touch upon that a little bit later. But let's return to the Cayman Islands example. Oh good, slide 6, 7, I'm keeping up. But we're going to do a quick quiz. If you thought you were just going to sit back and enjoy it, it ain't going to happen. How many of you in the audience obtain their knowledge of the Cayman Islands from John Grisham's book, The Firm? Come on, be honest. Yeah, good on you, that's one. Right, you'll get a prize for that, just being honest. Right, and I will in a minute. I tell you what, I reckon if John Grisham went on to the Cayman Islands, he'd be lynched. He honestly would. You wouldn't believe what that book's done for the island's reputation. The only way they got around it is in the movie they made everyone on the island an extra, which is a funny story in itself. All right, the next thing, who can point to the Cayman Islands on a map of the world? Right. Who has a negative view of the Cayman Islands? Come on, you've got to be... Who thinks it's a... Yeah, there you go. Don't know where it is. Does the Cayman Islands have any competitors in the Olympics, or are they part of the British team? Because it's a British... They have a team. How many? You know. No, but look, I'm impressed. You'll only still get one prize. Right. What is the currency of the Cayman Islands? Come on, money laundering. Everyone criticise them. Just tell me, what currency do they use? Is it the British pound? It's the British protectorate. Is it the US dollar? Do they have their own currency? Actually, that's probably the best answer yet. How many islands make up the Cayman Islands? No? What is the capital of Cayman Islands? Well, I suppose if you don't know how many islands there are, you probably don't know the names of them. It's a shame because I had prizes. Each of the prizes were worth $1.16 in case you had to declare it. And I'm going to give one to this gentleman. I might have to think of prizes. It's a Cayman dollar. There you go. I'll give you two actually. You answer two questions. I'll give you one of the old notes. You'll see the old queen and the new queen on it.
Do you exchange currency?
Yeah, $1.16. All right. Mr. Quang Nhu, again false name. I think it's actually more Vietnamese, but anyway, for my purposes, he's from the Philippines. He has a work permit on the Cayman Islands to be a security guard, and for the purposes of receipt of his salary, has opened an account with a BRAC bank, Cayman Islands. Right, BRAC is not a true bank, and by the way, the three islands are Grand Cayman. If you have a Grand Cayman, you must have a Little Cayman, and also Cayman BRAC. So those are the three. And as you can see, Cayman Islands does have its own currency. It's the Cayman dollar. It's pitched at $1.20 US, so it costs you $1.20 US to buy a Cayman dollar, which unfortunately I've negotiated everything in US dollars and the Australian dollars have just gone fantastically. So I'm losing money every day. But anyway, that's another story. But anyway, in Cayman Islands, you need a work permit to work. And Mr. Nhu had a work permit, but it was for a specific purpose. And if you don't have a work permit and you're working for a particular purpose rather, you are committing an offence. Now, at the time of opening the account, the BRAC Bank conducted what's affectionately referred to as KYC. Are you all familiar with the Know Your Customer regime? And that basically is the bank comes in and asks questions. That is an exercise, tends to be an exercise in form over substance these days, but the banks are finding out that they are putting themselves at great risk by not doing it properly, because they are at criminal risk as far as in one aspect, and they are at civil risk with their legitimate clients, because if they don't do proper KYC and their money gets restrained, undoubtedly you're going to see a flurry of lawsuits for losses in exchange rates, especially when you're dealing with offshore jurisdictions, because a lot of the times they're just an opportunity, basically jurisdiction through which the money flows. Anyone reading that Senate report will know what I mean. Anyway, the bank conducted its KYC where their customer profile was built, so they knew what their customer was meant to be about. The BRAC Bank took a copy of Nhu's passport, work permit and contract, which revealed he would be receiving between $1,800 to $2,500 per month. Now, Nhu was a well-known personality in his Cayman community, so he thought he would help his countrymen. He said, look, I'm going to help these people out by using my account to transfer funds on their behalf to the Philippines. And the reason being is you get a lot of people doing wire transfers and the bank charges them for each person. But if you do it as a group, the bank still charges you only the same amount. He was paid a small commission for his trouble. Mr. Ruddock, a manager with the Brack Bank, became concerned when he noticed that there were regular amounts reaching as high as $10,000 per month being wired by New to an account in the Philippines. He immediately calls New in for an appointment. Excellent. Seems pretty good so far. What Ruddock did not know was that New was also doing the same thing at the local widget bank, who immediately refused to take deposits or make the wire transfer, and in fact filed what's known as a suspicious activity report, also known as an STR, suspicious transaction report. I'd imagine at least half the room's familiar with those. Now, when the Financial Regulatory Authority on the Cayman Islands received them, they referred it to the Financial Crimes Unit, which, unlike Australia and all these Western world countries, is on the floor below or across the road. They ring up Bob, they ring up Steve, because everyone knows each other, which works really well. So Martin, who's the financial investigator, goes along and is suspicious of terrorist financing. So he goes to the bank and confronts them. Now, just if we take a slight detour, the bank, as we saw it, had already started committing criminal offences. They failed to disclose, and I'll tell you why. When you're talking about knows, it should have been he knows or suspects, sorry. It's an objective test. It's a reasonable person test. Knowledge, of course, isn't, but the suspicion definitely does. But B would have been particularly of interest to this bank. There was a failure to disclose. Second offence, we'd already identified. And just for what we really, even though they're criminal offences, we really considered them regulatory type of criminal offences because they don't really go to jail for a long time. But that's what they were looking at, a maximum of 5 years on indictment. So that was our starting point. It in fact got a lot more serious. New attends the office of the bank, that's Mr. Ruddock, and makes full admissions that he was transferring the funds, but he said, what's the harm in it? And actually, you know what? If you're not into business, you probably think, what's the big deal? These people are giving you money, transfer it overseas, and someone can pick it up at the other end. It's like carpooling, really, isn't it? But it's illegal. That's the only difference. Mr. Ruddock quickly advises him that it is to stop and puts the relevant alarm onto the computer to ensure that it does not happen again, because everything's computerised now. He tells New that he needs a licence to run what amounts to a money transfer business. Right, and that's the law that said that he needed a money transfer business. Mr. New tells Ruddock that he was not aware, but that he has a Caymanian friend that will go into the business with him. Where that is significant is that in Cayman Islands, to run a business, you must be Caymanian. Right, so you can't have expats going over there and setting up businesses. Actually, the true facts, and I don't know why I didn't include the true facts, is that the bank manager, this bank manager said, I'll be your Caymanian partner, because he could see just how much money could be made from this. So he further tells him that due to the great service he was getting from the Brack Bank, that he proposed the newly formed business will continue to bank with them. So we're saying, all right, well, we'll come in a partnership, we can build this into something huge now, and we'll bank through the Brack Bank. And the manager thought, this is fantastic, I'm making money on one end and I'm going to be promoted in the other end. It was going fine. Alarm bells ringing yet. Mr. Ruddock is familiar with the popularity of New in the Philippines and is excited about the prospect, of course. In the meantime, New has spoken to his lawyer along with his proposed partner, and all seems okay to forge ahead. Unfortunately, the process takes 2 to 3 months and his business is increasing. He says, well, I can't stop for 2 or 3 months. You can guess what happens, I'm sure. He then goes to the Brack Bank the following week and brings Mr. Ruddock up to scratch and says that the process is taking longer than he anticipated, and asks that Ruddock allow him to continue sending money for the period leading up to the licence issue. Ruddock, mindful of the fact that you may choose to move to another bank, agrees to allow the transfer as he accepts that you and his Canadian partner are going to make good. What Ruddock didn't know, and this is where the trap is for the bank, is which bank had already reported them. Right, so other banks were doing the right thing, which when it comes to trial, how difficult is it going to be for a prosecutor when you say, shouldn't you be doing this? He says, oh no, how was I to know? Well, Widget knew it. The Royal Bank of Canada knew it. Scotia Bank knew it. Do you see how the risk is ever increasing for them? The fire has well and truly ignited. So, still, that's not a problem for the bank. Why? Why isn't that a problem at the bank at that stage? Because they've got a block on the account, you would think. What Mr. Ruddock did, he had authority to override it. A single person had the authority, so he overrode it. Which is interesting because the bank won't get away with anything there, because my simple question was, why didn't you have two people? Two people at least would have made it just that little bit more difficult. Why wasn't it elevated every time it went through? So this risk is ever increasing. The job is actually quite easy for the prosecutor. Anyway, what Mr. Ruck, through the Proceeds of Crimes law, has made himself and the BRAC Bank, he's just made them accidental money launderers. That's what they are, they're money launderers. Proceeds of crime these days is defined so widely that it's the proceeds of any criminal offence and the profits, the benefits. On another day, what people find entertaining, and this is where this law addresses it, is, do you know at law, and you might want to go away and think about it, there is no such thing as a wire transfer. It's a commercial concept. What's being transferred in a wire transfer?
Yes.
What is?
Yes.
Nothing's being transferred. Nothing's being transferred in a wire transfer. Absolutely nothing. You might be extinguishing a shows in action and creating one of equal value in another jurisdiction, but nothing's being transferred. To conceptualise it, if I want to transfer 1,000 American dollars to the Cayman Islands and I go in there with Australian dollars, what have I transferred? I haven't transferred anything. But that is a very interesting talk for another day. So if any of you get the opportunity, you know where I am. Anyway, as soon as Mr. New takes the money from his customers without the requisite licence or work permit, we know he's committed the offence. There's your predicate offence. The proceeds of that crime become criminal property. The bank is not merely a mule in the same way as a drug carrier is. The whole proceeds of the crime become criminal property. And there it is. I won't bore you with the full definition, but go through the Proceeds of Crimes Act in the UK or the Proceeds of Crimes law in the Cayman Islands, and I think a number of other British protectorates and overseas territories have similar laws. It is a very, very wide definition. Now, once Ruddock allowed the transferring of the funds on behalf of the bank, he had committed money laundering offences, including removing criminal property from the islands, entering into or being concerned in an arrangement which he knows or suspects facilitates the acquisition, retention, use or control of criminal property. So that means any bank who meets the test of suspicion or knowledge, who opens an account, is facilitating an offence. And it's, in the UK it's known as a Schedule 1 offence. It's under Section 328 of their law, which invokes what are known as statutory assumptions. And just to give you an example of one of these statutory assumptions, if you commit an offence that invokes a statutory assumption, it assumes that every dollar that passes through your account, any property you've bought, anything you've sold in the preceding 6 years were from the proceeds of crime, unless you can prove to the contrary. And I'll tell you how effective that was with the as a prosecutor, because people were lying on their mortgage applications. If you get the money from the bank, they're the proceeds of crime. And of course, when anyone went to their mortgage, to their bank to get a loan, part of the GFC, I guess, they lie through their teeth about how rich they were. And of course, when we were investigating, the first thing we did is we went to Inland Revenue and said, how much did they declare to you that they had? And that Inland Revenue had given, and what they were doing, the commercial decision, which is the better one to enter the guilty plea on? The ripping off the Inland Revenue or the money laundering offence? It was amazing. And you know the sort of things that take into account, you wouldn't even think of it, is I want to travel overseas. Which conviction looks less serious that I have to declare when I enter the US or places like that? It's just amazing the sort of variables that comes into the decision-making process. But being frank, as a prosecutor, we couldn't care less. Person commits an offence, that was the example I gave you. That's section 134 of the Proceeds of Crimes Law, or section 328. That was extremely vulnerable for a bank. I've actually caught a lawyer out on that. I was prosecuting a lawyer in England. His most junior lawyer in the firm, he was on holiday, came along and said, shouldn't we be reporting this? And they went to their money laundering compliance officer. He says, yeah, I think so. And the guy came in and said, the police came in and said, yeah, report it. The partner came in, I don't know what was going through his head, and said, please don't tell us what to do, and allowed the money to go through. He was the only one charged out of all of it, and he did an Allen bond. It's remarkable how sick he became very quickly. And at the end of the day, I think they actually dropped the prosecution because he was ill, and they all sort of looked at the scenario as being, look, there wasn't actually an offence committed at the end of the day, so we won't make him the only one who's prosecuted. But I merely say that to say just how high risk this sort of stuff is if the prosecutors and the regulators start looking for it. And what's going to start happening, I'm sure, is you'll get regulators elevating things. They're going to say, you know what? Enough's enough. And I'll give you an example of that now. Sorry, I'm sort of straying a little bit, but I think it's interesting all the same. There was this company called Del Basso, and I'll get the, if anyone wants the case, I'll give you an email address, send it to me, I'll send you a copy, probably breaching a copyright doing it, but anyway. What had happened in that case was the English are as fanatical about their soccer as people in Australia are about the AFL and the rugby league and whatnot. And there was this soccer club, whose name escapes me, that operated not far from Stansted Airport. And they weren't doing very well in their league, and they were having financial problems. Now, in Del Basso, they had a benefactor. He loved his soccer club, said, what can I do? And he says, well, I own all the land around this soccer stadium. Every home game, why don't I let them charge £5, sorry, for parking, and they can, you know, make a bit of money out of that. Well, they were making a fortune out of it, which was going well. And he says, well, hang on. We're only about 5 or 6 k's away from Stansted Airport. Why don't we do a park and ride where we, you know, people will park their car for £5 a day instead of 20 closer to the airport, and we'll bus them to the airport. Whatever it costs us, we'll take out, we'll give the rest to the football club. Well, for that, you actually need a licence. So they went to their council, said, can we have a licence? The council said no, because there were environmental issues, traffic issues, all sorts of things that were okay on weekends when the football was being played, but through the week, no. So they appealed, and they were unsuccessful on their appeal. So they took advice, and they said, well, have we got another appeal avenue? They said, yes. And they said, what happens if we just do it? And they said, well, you'll get fined. And said, how often? What's a maximum? And they said, oh, £1,500. No, it was, yeah, £1,500. And he said, well, £1,500, we make about £1.8 million a year on this, and they've got to go to the trouble of breaching us. And so they said, we'll take the commercial risk, right? Remember I told you about that before? Bring in the CPS. CPS prosecutes them for a criminal offence. The $1.8 million were the proceeds, and the guy says, yeah, but hang on, we only took 180,000. We only took 10% to cover costs. They said, hey, you took £1.8 million. How you decide to spend it is your own business. Confiscation order, £1.8 million. And it happened even at a more fundamental level. A guy was bilking petrol, stealing petrol at one of these self-service garages, stole 200 quid's worth of petrol over 4 occasions. Young constable just was trained in proceeds of crime, had him in the station, looking at the paperwork, and he says, he's on welfare. He's on benefits, but his family lives in a property in the middle of nowhere in the country, which is renowned to be quite upper class. So whilst he had him in the office, he raced out to the property, spoke to the mother, did a title search. It was owned by a company. The mother was a director. And the mother said, oh, look, the son just sticks papers under my nose. I just sign whatever he tells me to sign. Long story short, he was convicted. He had a rap sheet, so he got put away for 4 months. Compensation order of 200 quid for the petrol he stole, and confiscation order of £1.8 million. Again, 1.8 seems to be a magic figure in England, but both of them were 1.8. And the beauty of it is, if he didn't pay it, he served up to 10 years imprisonment. And even after he served his time in prison, he still owed the money. And at the time, I don't know the outcome, the debate was, could he still be sent back to prison for the interest that accrued as it went along? So this is really big stuff. And that's why you had the comments from the likes of Justice Ungood at the start. These are simple offences. Look, this one here, a person commits an offence if he has possession of criminal property. We never charged anyone with handling anymore. Receiving, I think we may have called it here, you had knowledge the property was stolen. Don't need it, you only need suspicion. And they actually had the audacity in England, I can't get over it, that the court entertained it. They tried to get a charge set aside as an abusive process because they had a defence to receiving, but they didn't have an offence to the possession of criminal property, and it was an abuse, they tried to argue, by the prosecutor going for the easier option. Thankfully, they were not successful. But anyway, getting back to our scenario, we will see from Ruddock that not only has he put himself at risk of criminal prosecution, but he also put the bank at risk as well. And the bank, can the bank say, oh look, he was a maverick? Definitely not. They've even got that covered. All right, so you've got criminal vicarious liabilities. And now these are the real penalties. And it's 14 years imprisonment. If it was a conspiracy, it could be life in prison. It's admittedly, it'd have to be pretty bad, but if it goes on long enough, they'll try and make an example or two of people. Now anyway, around comes the you think the story ends there. Around comes the financial investigator who interviews Mr. New, who says that when the bank said it was okay, he thought he could continue. Actually, that's quite a legitimate response. He went around to the bank and said, oh, the bank thought it was okay. They knew the whole story. Do you see how the bank's now drawn in as an accomplice into this crime? The financial investigator then goes to the local branch of Brack Bank, and this is, I tell you what, as a lawyer, my jaw was really starting to drag on the ground now. I thought, this just can't get any worse. And believe me, it was getting worse every minute. The financial investigator then goes to the local branch, does a surprise visit on Mr. Ruddock, who is invited back to the police station to further discuss the matter. An hour later, Mr. Ruddock rocks up with legal counsel. That's fine. Everyone's got that right. Mr. Rumpole, we'll call him. But guess who Mr. Rumpole is? He's the in-house counsel of the bank. The last time he would have done criminal law would have been at law school, right? Our alarm bells rang then. We said, clearly, this bank has absolutely no idea of what they're doing. So if it was so obvious that they've got this wrong, what other things have they got wrong, right? So all of a sudden, they become the centre of intent. We don't really care about Mr. New anymore. We're wondering what this bank's doing. Anyway, Mr. Ruddock answers all the questions. You know why? Because Mr. Rumpole failed to advise him of his right to silence, continuing right to silence. Well, you know, the police told him. They only have to tell you once. You've then got legal counsel. He denies the version provided by Mr. New. Well, that's what you always do, you always deny, because he could see, oh no, my job's on the line now. Again, into post, he was sacked. Guess what? Another bank down the road employed him whilst the criminal charges were still outstanding. Guess what bank was on the radar next? It's just amazing how some of these banks behave. The financial investigator then indicates to Mr. Rumpole that he intends speaking to some of the tellers about overriding the stop direction on the computer. Mr. Rumpole indicates, now this is the lawyer, in-house lawyer, indicates to the financial investigator that he wishes to consider whether they should take part in the interview, and if they do, he wants to sit in on the interviews. In fact, Rumpole advises staff that they should take no part, and if they do, he should attend all interviews. He also discusses what they should and should not volunteer in the interviews. See, what they don't realise is the staff will tell us, you never get a full complement of staff that are happy. If they see an opportunity to sink someone, they'll sink them. Secretaries are fantastic, and ex-wives. Especially if there's a conflict between a secretary and an ex-wife. The stuff we find out was amazing. And it's true. You know, if I put this in a novel, people would say, look, it's just not realistic. Believe me, some of the stuff you see would absolutely amaze you. Anyway, besides being gobsmacked by Mr. Ruddock's ineptitude, or Mr. Rumpole's, thoughts start shifting to whether the bank should be prosecuted because it appears that they are trying to hide something. Now the focus of the investigation is shifting from prosecuting Ewan Ruddock to also investigating the bank for money laundering, and even considering investigating and potentially charging the in-house counsel with attempting to pervert the course of justice by telling these people what to say in interviews and what not to say. Right? These offences carry maximum terms of imprisonment of 14 to 20 years. You know why? Because in-house counsel said, he's a police officer, he's a flatfoot. This is a financial investigator from the Met Police in London. He's a nice guy, he's in the Cayman Islands because he wants to go scuba diving and get a good suntan, but it doesn't mean he left his skills at home. Right? So he was on top of the world. Anyway, after advice from the Office of the DPP, New is charged with work permit offences, money services offences, money laundering offences, jointly with Mr. Ruddock. Now, the offences, let's assume the bank had come along. The offences will ultimately be heard by a jury. To give an indication, you will have bank executives sitting in a dock. Everyone knows that people love bank managers and corporations because you do get that. We had those at conferences. We had, the Crown has to prove its case beyond reasonable doubt. I said, your judges are your target audience, the people you've ripped off. And this just doesn't impress them, right? Because, can we have that prosecutor stand up for a moment? Just stand up for a moment. Yeah? I'll give you $1 for it, okay? Smile. Doesn't that guy ooze charisma, right? That's what a jury sees. And for those of you who didn't actually get to see it on the TV, we actually did a photo beforehand of what these people look like. And that's what it is. You've got this, this guy in the dock, or those people prosecuting. That is not that far from the truth, believe it or not, because people go in there and they're not fooled easily. They're just not fooled easily because the offences are so obvious. And one of the things prosecutors are trained for internationally is to make difficult things seem really easy. And I remember a fraud involving a Christmas fund. I was describing it to someone, said, just imagine the presents were under your tree, the guy broke into your place and stole it from under your tree. This is just the same, it's just fancier way of doing it. They fully understand. Fraud, probably, I don't know the stats actually, I'm probably in the right place to get them, but fraud is probably has one of the highest rates of conviction because it's either on the paper or it's not. If you can see it, it's... And dishonesty, it's always an issue of dishonesty. And when the fraud gets really complicated, the mere fact that it becomes complicated is enough proof. I'll never forget, a New York prosecutor actually went to one of these economic symposiums, and we had a guy from one of the major law firms. I don't know how we conned him into doing it, but we did. He fronted up one of these workshops. And the question that the prosecutor asked was, why would anyone from the US need an account in the Cayman Islands? And it was as simple as that. And you should have seen the circles that this guy was speaking in, to the extent that by the end he just admitted that he was, yeah, they were probably criminals. Now, how am I going for time? I'm probably...
Fairly soon.
So, all right, well, I'll go through this quickly. I think you've got the thrust of what I'm going through. Corporate veil is irrelevant, by the way. May work in civil matters. Directors and officers' insurance. I haven't seen a policy where they say, we'll go to jail for you. Okay, so they're pretty not effective there. Whistleblowers are protected. Whistleblowers are encouraged, and they're also protected. I've given some suggestions which I don't need to go through with you guys because there's no one here from the private sector that can actually probably benefit from these, but making compliance your core practice, I think, is one of the things. Identifying and controlling mavericks is fantastic. It's pointless going to your staff and saying, we're going to run a compliance exercise today. That's like people going to church on a Sunday, right? They'll all go and they'll say the right thing. The rest of the week, they'll do what they want, or do as they please, rather. What you do is you run a marketing exercise with traps in it, and make the winner the person who's got the greatest profit. And then when you're just about to give them their prize, get police, pretend police of course, to come up and arrest them for everything they did wrong. Whilst they're really embarrassed at the time, believe me, the message gets there and they'd be far less embarrassed in the exercise than if it happened in real life. Also, oh right, sorry about that, I didn't mean to do that. Going from bad to worse. Anyway, what else happens is there are a lot of sources for evidence to convict people. You've got employees. Government employees in UK are actually bound under the Bribery Act to report certain things, or they commit criminal offences. So you're going to have a lot more police out there. Competitors will always, you know, tell on their competitors. I think regulators, ACCC definitely, I think, experiences this a lot, where they'll say, look, we're playing by the rules, the competitors aren't. So they'll tell them. Barclays, for example, when they had the recent LIBOR incident, as part of their agreement, ratted on a number of other banks. We all heard about Virgin Atlantic ratting on British Airways for their price fixing exercise. You have incriminating email. I've told you about the compliance manuals, bad legal advice, bad recruitment, recruitment's improper, and training. The new third-party law that comes around, you know how we all know the ambulance chases? I'll tell you what the new ambulance chase is going to be, is key tam litigation. Have you heard about key tam litigation? How it works is fantastic in the US. What they do is the first person who whistleblows, if they're prosecuted and they recover, they get 15% of whatever's recovered, and we're talking millions of dollars, especially with defence contracts. If you prosecute yourself, which you can do, and that's going to be another burgeoning business, you can get up to 30%. You'll see lawyers making a lot of money from that, and so you'll see that blossoming. And civil recovery under the Proceeds of Crimes law. Now, OFAC, sorry, I did it again. If I can end on an example from the recent HSBC situation, OFAC, which I keep throwing around, sorry, I should have defined it, is the Office of Foreign Assets Control in the United States. It started just after World War II, and it was It was a way the government would basically vet the assets coming through the United States of what it considered to be its enemies. Well, this office has been basically going along since the 1950s, and of course the list changes, and as no one would be surprised, Iran is now on that list, modern day Iran. And so what happens is whenever there's anything, paperwork that goes through software they've developed that identifies an interest in US dollars from Iran, it would ring the alarm bells and stop it. So what these banks decided to do was they disguise any of these entries so that it'd be bank to bank and the filters wouldn't pick them up. How is that not being an accomplice in a crime? This thing was set up exactly to identify these, and the banks were doing it. Rather than look innocent, this is the email that floated from one office to another. In this way, a payment in US dollars can be made for an individual or company on the OFAC list without the name being detected by the OFAC filters. Is that a conspiracy? That's all the evidence you'd put to the jury. You could say, there it is, I sit down. They plead guilty to that. The problem is, and this is perhaps where the regulators have got to start looking at themselves, is people are okay with pleading guilty to that because it's in their budget. No individual becomes answerable. In fact, they'll leave the company and criticise their ethics and their culture of non-compliance as they move on. Start prosecuting the individual and I think you'll see a different outcome. I started with a quote from an English judge. I thought I'd end with an Australian judge. And I think that probably better resembles the way we are progressing today. Look, I'm sorry I ran over time, people. I really did. Believe it or not, I intended to cover a lot more, but I'll probably be here still till tomorrow.